Good morning. My name is Morgan Petipa. I'm an advocate investigator with Disability Rights Florida. I appreciate you all for coming today and starting your cafe experience this way. Today I'm going to be presenting a presentation entitled Understanding Your Options, Supported Decision Making, Guardianship, and More. Okay, so just a little bit about Disability Rights Florida before we begin on the substantive material. Disability Rights Florida is Florida's designated protection and advocacy system, or P&A. Okay, every state has one of these. We are Florida's. Our mission is to advocate, educate, investigate, and litigate to protect and advance the rights, dignity, equal opportunities, self-determination, and choices for all people with disabilities. We also have the funding, responsibility, and authority under 9 federal grants to protect the rights of Floridians with disabilities, and we've been doing so since 1977. And we are unique in that Disability Rights Florida has the access authority to any agency, institution, and organization that serves or houses people with disabilities. This is a power that other agencies do not have, which is why we're unique in that way. Okay, so I'm going to go over the agenda, and it might seem a little long to you, but I'm going to try to get everything covered today. First, we're going to discuss what supported decision-making is. Then we're going to discuss the role of the supporter. We're going to compare SDM, guardianship and guardian advocacy, power of attorney and healthcare surrogate. We're going to have a discussion about those two documents for a little while. And then we're going to go to my favorite slide, which is the presuming competence slide. We're going to talk about the dignity of risk, why we use SDM, how to use SDM, the current SDM law, and the protections for decision makers. We're going to go through some example client scenarios. These are hypothetical, they're not real clients. And then we're going to answer some questions. Okay, so we're going to start off. What is supported decision making, right? Many of you who have come to this presentation today, that might be the first question off the top of your head, right? Supported decision making, or SDM as I will refer to it throughout the rest of this presentation, is a collaborative process between the decision maker and their supporters. The person crafting the supported decision making agreement, the person with a disability, you are called the decision maker. Your supporters are aptly titled supporters. The decision maker is the individual with a disability, as I just mentioned. Their supporters are trusted people they can rely on to help the individual with a disability. And the reason that word is emboldened there is because that's what you're doing. You're helping the individual with a disability. You are not making decisions for them. So you are trusted people. The supporters are trusted people that the individual with a disability or decision maker can rely on to help the individual with a disability make decisions and understand the consequences of those decisions. So what is a supporter? What's their role? That's often the question that I get the most, okay? So a supporter does not make decisions for the individual with a disability. And that is the first point on this slide because it's the most important. You're not making decisions for the individual with a disability. You are simply helping them. You're their support system, their rock, the people that they rely on to help them weigh the pros and cons, do all the things to make sure that they're making the best decision for themselves, right? Instead, the supporters are there to assist the decision maker in making decisions, right? This can be in the form of answering questions, conveying the individual's decision to another person. The individual might be nonverbal, may not use an AAC device. So therefore, you may need to relay the decision to the third party. They also can help the individual with a disability understand the meaning and significance of a decision, weigh the pros and cons, understand the gravity of a decision. And those are often the roles that I see the supporter take the most. There are many others, but those are just a few. Okay, so here's my big chart, right, that compares SDM, guardian advocacy, limited guardianship, and what we call plenary guardianship, which is full guardianship. Okay, with SDM, there are no court proceedings required. You're not going in front of a judge. You're not going in front of an administrative law judge. There's no court. The young adult is assisted by trusted adults. The trusted adults are the supporters. The young adult is the decision maker, right? And the SDM agreement helps teach decision making. And I will tell you that I see this firsthand, because oftentimes I have scenarios with clients where I go in and I help them draft SDM agreements, and they come to me and say, Morgan, I don't know how to make a decision. Or my mom or my dad or my grandma or grandpa always helps me, right? But by the end of the process, they're like, oh my gosh, I can make a decision. And the light turns on in their head, right? There's it's like a eureka moment, for lack of a better term. And then with SDM, no rights are removed. Self-determination is preserved, and that is the biggest plus. I'm gonna step on my soapbox here for 2 seconds. That is the biggest plus of SDM, because no rights are removed. And the individual is able to keep their rights intact while still having the help with decisions. And it can be used with other alternatives, like guardianship, for example. It can be used with guardianship, if the guardianship is already established, of course. But I often see individuals who come in for just an SDM agreement. With guardian advocacy, right, you must meet the definition of a developmental disability, okay? And there's no finding of incapacity required. So you're not having an incapacity determination. Therefore, you're not having an examining committee of 3 or more members come in, examine the potential ward, and then, go from there as to whether or not they're incapacitated. The guardian advocate on paper, ideally, must consider the wishes of the ward, okay? And only the specified rights are removed. So it's not all. It can be all, but most of the time it's not. Okay, with a limited guardianship, that's a little bit more restrictive. So we're going in order of restrictiveness. Limited guardianship requires the examining committee and a court finding that the individual lacks capacity to exercise some, but not all, decision-making rights. And the court decides which of the rights the individual retains and which rights are delegated to the guardian. Plenary guardianship is the most restrictive. Plenary guardianship requires an examining committee and a court finding that the individual is totally incapacitated, right? All rights are removed. It's very hard to get out of guardianship. I have done unwindings. I'm doing unwindings as we speak. It's very difficult. It's a time-consuming process. Delegable rights, meaning the rights that are delegable to the guardian, to the potential guardian, are the right to contract, sue and defend lawsuits, apply for government benefits, manage property, determine residence, healthcare decisions, social decisions, and about their environment, okay? The non-delegable rights, the rights that can't be given over to the guardian, are the right to marry, vote, drive, travel, seek or maintain employment. Okay, so those are some differences amongst all of the alternatives. Power of attorney, that's a little bit different. So often when I get somebody who comes in for an SDM agreement, I will offer power of attorney as an option as well, okay? So the power of attorney, there's 2 players. We have the principal. The principal is the individual under the power of attorney or the individual with a disability. And the agent or agents are individuals who the principal appoints to delegate powers to. Most often you see this in financial situations. I often give the example of, if I have a power of attorney where I want mom as my agent and mom is going to go, manage my bank account, right? She has the authority, once I draw up this power of attorney, to go to the bank and withdraw $25 from my account. No questions asked, okay? A durable power of attorney is a power of attorney that survives a determination of incapacity. So once the individual is determined incapacitated, that durable power of attorney stays put. Rights are not removed from the principal. They are simply delegated to the agent. So they have the opportunity to exercise their rights or have the agent exercise their rights on their behalf. Powers are delegated to agents, like I just said. For example, withdraw from an ATM, right? I go to the bank, I have mom withdraw my $25, or I go to the bank and I withdraw my own $25. And they must act in the principal's best interest. Excuse me, just a second. Okay, here we go. Designation of healthcare surrogate, right? This is also offered as your package that I present when I do your SDM agreement, right? A designation of healthcare surrogate is exclusively for healthcare decisions. The surrogate that is named by the individual with a disability makes healthcare decisions only when the individual is unable to do so themselves. This could be for being under anesthesia, for example, or God forbid, if they're in a coma, they can't make decisions for themselves, then the healthcare surrogate kicks in. But what you have to understand, and I'm going to pause here real quick, right? So with a healthcare surrogate, if I'm doing an SDM agreement and a healthcare surrogate at the same time, my SDM agreement covers healthcare decisions. So does my designation of healthcare surrogate, right? So the designation of healthcare surrogate does not kick in until that person is deemed incapacitated. Otherwise, the SDM agreement trumps. And this takes effect, like I just said, only when the individual is unable to make decisions by themselves. The person named as a surrogate can consent to treatment and transfer to and from medical facilities. So you can withhold treatment, consent to treatment, etc. The surrogate appointed should be someone that the individual trusts, obviously, right? So that's often a conversation I have with my clients. Do you really trust this person? Do you trust them to make healthcare decisions when you yourself cannot? And it is signed in the presence of two witnesses. So my favorite slide, possibly my favorite slide, I don't know, there's maybe more than one, is presuming competence, right? So legally, every person is presumed competent unless a court deems that they are not. Legally speaking. I went to law school. I will know. Unfortunately, many people assume that all people with disabilities are unable to make their own decisions, right? In society, that's what we see. I'm a person with a disability. I have cerebral palsy. My walker is somewhere in this room. But I will tell you that oftentimes people assume that just because I walk with a walker or crutches, that I cannot make my own decisions. Spoiler alert, I can. Right? So SDM is based on the principle that we flip the script of society and presume that individuals with disabilities are competent to make their own decisions. We change the narrative a bit, right? And there is no requirement that a person make only good decisions, just that they're able to make decisions. Every day, we probably make one or more bad decisions. Any neurotypical person, right? So we're not foolproof as humans, right? So, I make bad decisions all the time. And yes, I'm an individual with a disability, but like I just said, we're not foolproof. And, we're not expected to just make good decisions all the time. In fact, bad decisions allow us to learn and grow and thrive, and we'll talk about that in a second. Needing extra time or explanation does not mean a person cannot make their own decisions. And I will tell you, I have personal experience with this because I work with many nonverbal individuals who draw up SDM agreements. And I have to stop and pause and wait until they themselves can indicate what their decision is when we're drawing up their SDM agreement. And that decision holds no less weight than someone who is verbal or someone who is more mild, right? So this allows us to understand that people with disabilities can make choices to the extent they are able, even if it looks different than what you may have imagined. Like I said, I work with a lot of nonverbal individuals. I do a lot of SDM agreements that have pictures on them so that the individual can make their own decisions. Every SDM agreement, and we'll talk about this in a second, looks different for everyone. No SDM agreement looks the same, and that's okay. The process looks different for everyone. Hold on just a second. Technical difficulties. All right. So why do we use supported decision making? It helps to build and maintain independence. Like I said, that light bulb that comes on, right? When they realize I can make a decision, suddenly they're able to be a little bit more independent in their ability to make decisions. And it builds their confidence. I've had clients who come to me and they sit in front of the computer screen and they say to me, Morgan, I can't make a decision. I can't do it. And I don't know what to do. And I'm always relying on my parent. I don't know what to do. And then all of a sudden, ding, the light bulb comes on. And they realize I can make a decision for myself. And it wasn't that hard or scary. And it's a beautiful moment. That's why I love doing this. It allows individuals with disabilities to grow as people and make their own choices, right? We talked about growth. We talked about the fact that, making bad decisions allows you to grow. Making good decisions allows you to grow, right? It prevents abuse because the rights aren't taken away. So they have the authority and the autonomy to exercise their own rights. It allows individuals with disabilities to preserve their rights. The rights aren't taken away. It increases confidence. And it increases education and employment opportunities and improves outcomes. So how do we use SDM? Well, SDM can be used in a written formal agreement or a more verbal agreement. Most often I see it used as a written formal agreement. That's what we at Disability Rights Florida do. I have a template that I use with each of my clients. But it can be an informal verbal agreement as well. Supporters can meet with decision makers as often as the decision maker would like to discuss the decisions they need to make. This can be once a month, once a year, once a week, bi-weekly, doesn't matter. An SDM agreement can be used in combination with a healthcare proxy for medical decisions like we talked about before, or even a power of attorney document. And like I said before, SDM agreements can look different for everyone. I have some clients that come to me that check off every single box on that document. And I have others who only check one or two. But you know what? Their ability to make decisions is no less valid than the other. Because seeking help doesn't equal inability to make decisions. So, Florida's SDM law. This is super exciting because while I was here at the Family Cafe last year, the law was signed and passed as I was giving my presentation. It was passed in 2024 and was supported by self-advocates. Legally speaking, it is located in Section 709.2209 of the Florida statutes, and it falls under the power of attorney statutes. But it differs from a standard POA as we discussed. A POA delegates rights. SDM, really, it's a collaborative process. So, there's 3 things to know here, okay? The new law ensures that courts are aware of SDM. And this is important because a lot of judges weren't aware of it before it was passed. There is a notarization requirement, and I do make my clients aware of this every single time I do an SDM agreement. Before you use this agreement before you put it on file with the doctor, the teacher, the school district, whatever the case is, right? You have to have it signed, witnessed, and notarized in order for it to be effective. So you go to the bank, get it notarized by the bank notary or an online notary, it doesn't matter, but it has to be notarized in order for it to be effective. And it can be revoked in writing at any time. This is great because you're not stuck. The choices that you make, the X's that we mark on your agreement when you come to me and we do this, aren't set in stone. It can be revoked at any given time, meaning it can be terminated at any given time. And it includes protections for the decision maker. For instance, on our supported decision-making agreement template that we use at Disability Rights Florida, we have contact information at the end for the Florida Abuse Hotline in case the decision maker, a third party or someone is aware or suspects that the decision maker may be being taken advantage of or abused or neglected. So, protections for the decision maker. Legally speaking, statute-wise, there are protections for the decision maker that SDM kind of falls under. So we have section 825.103 of the Florida statutes, which is exploitation of the elderly or disabled persons. Section 709.2114 of the Florida statutes, right? And the supporter is a fiduciary, meaning they have to act in the decision maker's best interest. They have to. The supporter cannot act against the decision maker's best interest, like I just said. And third parties must accept or reject the agreement within a reasonable time. This is super important. I'm going to pause. They have to. So if the doctor doesn't agree, the doctor has to reject it in a reasonable time. If I go and I place my SDM agreement on file with the school district, and the school district says, I don't want to honor this, cool, reject it in a reasonable amount of time, we're good to go. But they have to do it in a reasonable amount of time. And if someone refuses to accept the SDM agreement, they must tell you why, give you a justification in writing. In writing. They can't just say, sorry, no can do. They have to tell you why in writing in order for that to be effective. And then you come to me and we talk about it, or you call me after I've closed your case and we talk about it and we kind of figure out why and where you go from here. So now for the hypothetical client examples, because I think these are super important. It shows you how diverse of a population can use supported decision-making agreements effectively. So SD, right? SD is an 18-year-old with a physical disability who wishes to attend a university to study engineering. And SD's high school guidance counselor recommended guardianship, and I'm going to pause real quick. There is a well-known school to guardianship pipeline that happens. When you go in for that transitional IEP meeting, you will often hear the terms, you will often be asked the question, well, have you considered guardianship? My own parents, I have mild cerebral palsy. My own parents, my dad is sitting at the back of the room today, have been asked that question. They have been asked that question and they're like, no, we're not considering guardianship for our kid, but you will often be asked that question, right? And so that was what happened with SD in this hypothetical scenario. So SD needs support making medical decisions and handling finances. And they also need support making decisions about their living situation in college. So SD comes, they do an SDM agreement, and SD's mom and dad are named as supporters in his SDM agreement. SD also elects to have a designation of healthcare surrogate drawn up as well. GK, on the other hand, is a 22-year-old with an intellectual disability. GK is nonverbal and communicates with an AAC device. GK needs support in virtually every area of decision making or all areas of decision making, but expresses her choices via her supporters and her AAC device. Her grandparents, so she comes, we do the STM agreement, her grandparents are her supporters. And she elects to have a power of attorney drafted as part of her SDM agreement. So those are two drastically different examples of hypothetical examples of people who have used supported decision making. And I see that every day because at Disability Rights Florida, currently, I am the one that does supported decision making agreements. If you call about an SDM agreement, you will likely be assigned to me. So I have vast experience with all different types of clients and how they use SDM agreements. And we sort of, the process is different for everyone. So, sometimes I'll institute breaks as sort of an accommodation and say, okay, you want to do half of it for this appointment and then we'll do the other half next week. Or sometimes they just want to get it done in one fell swoop. But, and I've had verbal and nonverbal individuals, and I've had people who, come to me and they're like, I know what I want. I know what decisions I want to make. And then I have others who are like, I have never made a decision before in my life. And this is crazy and weird and I don't know what to do. So, that's sort of the gamut that my experience has run in terms of the types of clients that I see. Now, I will say, because I did not point this out in this slide, but you have to be, so you can be 17 and draft an SDM agreement, but in order for your SDM agreement to be effective and be signed, you have to wait to sign it until you're 18. Okay? So often, I'll have transition age youth that come to me and they will, that's when they start to draft their SDM agreement. But typically, you can draft it at any time, but it needs to be signed when the child is 18. So one final reminder, right? I always remind my clients that it is perfectly okay to ask for help and to ask for all the help you need to make decisions. We all ask for help at times. I mentioned myself. I often use my personal experience in my appointments with my clients because I am an individual with a disability and a proud one, okay? But I'm almost 28 years old. I'll be 28 next month. And I've gone to law school and gone to college and done all the things and checked all the boxes, right? But I still ask for help making decisions. I live with my boyfriend. I live alone. I don't live with my parents anymore. But I still ask for help. I'll call my dad 22 times a day and ask for help making decisions. And there's no shame in that. There's no shame in that. And I try to instill that in my clients, that it is okay to ask for help. And there's no shame in any of this. And it is vitally important that each SDM agreement is uniquely tailored to the individual it is created for. Like I said, every SDM agreement is different. No SDM agreement is the same. And that is okay. The process may not look the same. I may have someone who comes to me, in March, right? And then they're like, Morgan, I want to take a break for 3 weeks, and I'll come back to you in 3 weeks, and then we finish it up. Or I have someone who comes to me and says, I want to check all the boxes on this document. And then they come to me and they're like, you know what? Nah, I've decided against that. Let's do it a different way. Or I have someone who comes to me who is nonverbal, and the parent will come to me and they'll say to me in the camera, in the video chat Teams camera, they'll say, Miss Patipa, I don't really know about my child. They're nonverbal. They're unable to make decisions. I've never seen them make a decision in their life. And I say, okay, well, let's see about that. Step to the side, go out of the frame so that the person can make a decision for themselves. And that's what happens. They have this wonderful, almost magical moment of like, I can do it. And it's awesome to witness, because I think a lot of times, especially for those individuals who are, the parents that come to me and they're like, I don't know, I'm skeptical, we looked at guardianship, I have an appointment with an attorney, all these things, right? And then they come to me and they do this and they're like, whoa, I did not know that my kid had the ability to do that. And I'm like, well, they're not a kid, they're an adult. But also, yeah, like, presume competence, presume confidence, presume confidence. And that's what I do every single day, right? With every single one of my SDM clients. And they're unique to every single person. Like I said, no one looks the same to the other. And that's cool. So, any questions? Sure. I'm going to go front to back, right? So, closest to the front right here.
Okay, so I know you were very, very good. Thank you for going over everything.
Mm-hmm.
You may have said this, and maybe it just kind of went past me, but so as a parent, I have a 17-year-old son, and I'm trying to figure out. I'm learning, right? So you said don't assume that he's not competent, but sometimes I'll say like, what do we want to do this weekend, or what do you feel like for dinner? So like even things that are just very basic, sometimes it's like pulling teeth to get an answer.
Okay.
So because I'm his parent and I'm being realistic, I'm like, what's it gonna look like if he's 18 and something happens? If he has something that's a health or medical, like, so I start thinking maybe I should be the full guardian. Maybe I should be in charge. So I'm kind of in this, I want to help support him to be independent.
Mm-hmm.
So it sounds like, yeah, I want to be this person. I want to be the person that can support him. But at the same time, I'm not sure if that's the right thing. So what do you do when you're on the fence?
Yeah. So I have a lot of parents who come to me and they're like, I'm in limbo. I don't know. It's like pulling teeth. I hear that phrase all the time. It's like pulling teeth. And your loved one with a disability best, right? I don't know them. But what I will tell you is at the beginning of every SDM appointment or every SDM case that I do go through a questionnaire. And the questionnaire basically is like, do I know how to plan what my day looks like? Do I, all these different kinds of questions. And we talk about it. And I really determine whether or not they're a candidate. Now, as far as being on the fence, again, it is really up to you. But know that once you take guardianship, you are taking their rights away. And it is very difficult to unwind that. I'm doing unwinding. I think I just said this at the beginning. I'm doing unwindings right now, and it's very difficult. You have to go through the court system and everything. I'm doing it with the assistance of one of the attorneys at DRF. But, so I think you really go with your gut.
Do we sit through the first appointment together?
Yes. So it is a collaborative process. You sit through the first appointment. We go through the questionnaire. We talk about it. We discuss. We talk about your fears. We talk about the individual with the disabilities, hesitations. Maybe they're, why haven't they been able to make these decisions? What's stopping them, right? And then we kind of go from there. And oftentimes they will open up. And you will realize that they're a lot more capable than you may have thought. So when you're on the fence, I would say, our services are completely free at Disability Rights Florida. I would reach out to our intake line, let them know that you've attended this presentation, and then they will go on and make sure that the case, it's not a guarantee of assistance, but make sure that, if the case is accepted by my supervising attorney, that it is sent most likely to me. Okay?
Thank you.
Of course. All right. I'm going to go to that hand first because right here, the little guy, because you were waiting. So go ahead.
Okay, so on slide 14, was it actually 3 things to know or 4 things to know?
Well, you may have called me out there. Let's see. Oh, there's 4 things to know. I am so sorry. I should have changed that in my title. I am so sorry. All right. I will, when I get back to the office on Monday, I'll do that. All right, go ahead.
So, I have a daughter, 33 years
Mhm.
old, with Down syndrome, and she completely trusts us,
Mhm.
and we try to, guide her in her decision making. But we encourage her to make decisions, daily decisions, and what she wants to try next.
That's great.
All those kinds of things, what kind of
That's great.
classes she wants to join, etc. But she, we don't have anything like this in place.
Mhm.
So, how would supported decision making? What difference would it make, and how would it help?
Okay, so oftentimes, and I get this question a lot, you're gonna go place this on file with things like you said your daughter's 33, so I'm gonna use her as an example, right? The doctor's office, okay? The doctor's office, maybe they're saying, oh, you can't come back into the, exam room with her because she's 33 years old, she's over 18, and you can't talk to the doctor, but that's how it will help. In her scenario, you'll place it on file with a doctor. You'll place it on file with, if she's part of any supported employment, anything like that. So that you are involved in the decision making and that they can't really stop you, right? And it's a legal document now. So it becomes, it's, I think, especially right now, I'm going to step on my soapbox again. It's vital. It's vital because it is now a legal document. So no one can say no and then just scoff and turn away, right?
Just one part of it.
Mm-hmm.
Can it be both parents or?
Yes.
It can
yes.
Be.
So it can be multiple for everyone. So he asked, can it be both parents? Yes, it can be multiple supporters. Okay. So oftentimes I'll have 2 or 3, sometimes more. I'm not going to go in order anymore because this is nuts. All right, go ahead, right here.
So in reference to the SDM
Mm-hmm.
versus like other legal documents, one of the things that came out, and I just want to double check. I can have one person. In my case, my brother is 78.
Okay.
And so, there could be 1 or 2 people for the medical and another 2
Yes. Yeah.
for like financial.
Yes, it can be. So different supporters can have different roles or they can all have the same. It doesn't matter, right? So I can have 2. So she asked, can you have different supporters for different things? Yes, you can have different supporters for medical decisions, different supporters for, financial, different supporters for social, whatever the case is. But this decision maker, the person with a disability, has to be okay with that, obviously. Of course. In the back. Mm-hmm.
Is there a long wait to get to them?
So, our intake team is wonderful. They will try to get you assisted as quickly as possible. If you tell them that you know me from Family Cafe and I can actually give you my direct line for you to call, and I will refer you to intake and have them do their thing that they do over there, it shouldn't take super long. But I mean, I get new cases every few days. So, I mean, you should be fine as far as wait.
And are all the calls done virtually, so you don't have to come to class?
Correct. So I work remotely, and so all of the calls are done via Teams, which you don't have to pay for. It's a free software, and then that's how the calls are completed. Mm-hmm. Yep.
There are times in a medical situation where she's in a crisis, her anxiety is bad, and probably wouldn't want them to give her an injection or take blood or something, and would say no. Is that where I would need a medical proxy on top of that?
So we can talk about that. I think, it looks like it might be needed. Both might be needed, but we'll talk about it, when you come to me and we have that initial conversation, we'll talk about kind of what the needs are and how you can best be helped. Okay. And what will make the individual with a disability the most independent while getting the help that they need. Mm-hmm. Go ahead. Yes.
Quick question.
Mhm.
So on your SDM, like we're right now, the primary caregivers for our daughter.
Okay.
But in the future, we plan for our son and his wife to be.
Mhm.
Would it be better to go ahead and set it up for all of us now, or would it be better for us to just be doing and then just
So
later?
so it can be changed or revoked at any time. So what I would say, personally, if you were to ask me that question like in a client call or something, I would say, I would have all of you do it now, and then you can remove whoever you want. Like you can go and draft you can come back to me and draft a new one and remove the individuals you want to remove and keep the individuals you want to keep, right?
And will this help, like, if I call the doctor and need records that
Mhm.
they don't say, oh, well, I have to
So-
talk to her. What about
So
things like Social
right,
Security?
right. Okay. So you can have a HIPAA release attached to that SDM agreement, and that will allow you to, have access to medical records, etc. As far as like Social Security, I get that question a lot. Typically, when you go in for like a Social Security interview or something and you want to place it on file with Social Security and say, my daughter has an SDM agreement, here it is, read through it, blah, 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 whatever. If they accept it, you can go into that interview and you can help the individual make decisions. And I don't know your daughter's specific situation, obviously, but like, you can communicate they can communicate via you if that's needed, but you can't make decisions for them. It has to be collaboratively.
They won't even talk to me.
I know.
And give me information.
I know.
And that matter of fact, they said, what is her Social Security number? I said, hang on, let me pull it out because she doesn't have it memorized. I said, you can't do that. I said, I can't get it out of my filing cabinet for her.
I know.
And they
I
said,
know.
no, she has to. I'm like,
No, I know.
she
I
doesn't
know.
know where it is.
I know. So that you can place it on file with the Social Security office, and I've had clients who have done that and have had success. And they're annoyed. The Social Security reps are annoyed, and they're like, well, what is this? I don't really know what this is, but they're learning. So yes, you can. It will help with that. You can also attach, like I said, the HIPAA release to have you be able to access, healthcare information,
One last
medical
question.
records. Yeah.
Guardianship advocacy.
Guardian advocacy. Mhm.
Guardian advocacy. Does that require court involvement?
No, we at Disability Rights Florida do not do guardian advocacy. We do not do guardian advocacy. We, because that is taking away rights. It's again. I'm also doing unwindings of guardian advocacies as we speak, and it's a long process. So if you want to, but guardian advocacy does require court involvement. It's just that there needs to be no examining committee, no result that the person is incapacitated. Sure. And any other questions? Yeah.
Is that only recognized in Florida because this Medicare Advantage plan is out of state?
Yeah. Okay. So that's a good question. So is it only her question was, is it only recognized in Florida? So Florida has a supported decision-making law, in which they recognize, SDM. Some states do not have these laws, written laws. However, I have had like clients that will bring a copy, a laminated copy of their supported decision-making agreement on vacation with them or whatever. And if they need to use it, then, we'll say, okay, well, this is valid in Florida, right? So if it's valid in Florida, the idea is they should recognize it. And the insurance company, especially like his Medicare, you're talking about Medicare Advantage, the insurance company, doesn't matter where the Medicare Advantage plan is, doesn't matter. They should recognize it, period. Yeah, go ahead.
Right now he has healthcare surrogate, and they wanted, his health plan wanted the power of attorney for me to call to request his change of provider. If I get the power of attorney, why would I still need the SDM or?
So the power of attorney is limited to certain things. So it can be limited to healthcare, it can be limited to financial. It's not really all encompassing. So I would recommend, if you're asking me my opinion, I would recommend that you have the SDM as well. But you don't have to if you don't want to. It's just a way for you to be able to be a resource when they're making all types of decisions. But I would personally, professionally speaking, I would recommend it. Mm-hmm. Yeah, go ahead. Go ahead.
My quick question is, you said if they take your case, so what is that?
Okay, so our intake process is kind of convoluted in a way. So you call our intake line, excuse me, you call our intake line, and one of our lovely intake staff will assist you. They will talk to you about kind of what your needs are, etc. This is for anything, not just SDM. It's for Medicaid disenrollment, whatever the case is, right? So they will assist you, and then you will. So your case will be forwarded on to my supervisor. Like if it's an SDM case, my supervising attorney, who is wonderful, and then she will go review that to see if we can accept the case, because there are certain cases that we do accept, certain cases that we don't, based on our goals, priorities, and objectives, based on our team's current work plan. I will tell you that I am not obviously in the intake department, so I don't see how many SDM calls they get a day, but I do get a large amount of SDM cases on my caseload. So it's more than likely that she will accept it, but we just say that you talking to an intake specialist with our intake department is not a guarantee of assistance. So they could take it, they could not, but like I said, I have a large volume of SDM cases that I've done, so I would have to ask one of my colleagues in intake if they ever reject SDM cases, but I don't think so. Mm-hmm. Any other questions?
That was gonna be my question, what criteria would they reject? And I'm sorry, I missed part of this, because traffic is abysmal.
Sure.
But an SDM, do you have to have an attorney?
No.
Does that take away some of the rights? Or what exactly does it do?
So, little crash course real quick. So SDM does not take away rights. You do not have to have an attorney. I am not a licensed attorney yet. I am taking the bar and waiting for results and doing all the things. Thank you. But you do not have to have an attorney. It does not take away any rights. Okay. And you're essentially just a supporter for the individual with a disability. So it's a collaborative process in helping them make decisions and being there for them to kind of weigh pros and cons of decisions, make decisions, the best decisions for them, but you're not making decisions for them, you're simply helping. Yeah.
How high functioning do they have to be?
Doesn't matter. I'm just going to say I don't like the term, I don't prefer the term high functioning or low functioning, but I've had people all throughout kind of the severity levels of disabilities. I've had a variety of disabilities, autism, Down syndrome, cerebral palsy, et cetera, et cetera. So really it doesn't matter, because I don't know if you were here for this part of the presentation, but every SDM agreement is unique to the individual. So I've had agreements where, they are able to only nod their head yes or no. And that is how we make it through the process. and I've had people use AAC devices and people who have SDM agreements with pictures on them, to help like kind of a PECS kind of system, so it doesn't matter.
But like the hospital or the doctor's office, because I understand this is a law in Florida now, they have to accept it, correct?
So if they so they generally have to, yes. If they reject it, they must tell you why in writing, and then you come back to me and we say, okay, well, how do we get, like, what do we do, right? And so where do we go from here? But they have to tell you why in writing if they're going to reject it. But yes, typically they because it is now a legal document, they can't just turn their head and scoff and walk away. They must at least consider it.
All right, one last question.
Yeah.
Please. Okay, so let's say we call you in and converse with the intake specialist. Then how long does the whole process take from conversing with that person to when we get the actual document?
So the process itself, so the intake process, typically, I mean, from intake when it comes to me, maybe a week or two at maybe the most. There's sometimes really backlogged. We have a lot of callers for a lot of different things, and then from me, so we'll do the appointment with the questionnaire, where I'll go through the questionnaire and we'll talk about like what areas of support they need and what areas they don't need support in, right?
Can we do this over the phone?
We can. I do like to do it via, Teams or Zoom, just because the individual I can see the person and the person can see me, and they can see the document. But I can do it over the phone. I prefer to do it over Teams or Zoom.
Okay, and I'm sorry, continue. So how long does that take?
So it takes so as far as to get the document completed, if you just do the SDM agreement and say it takes, we do it all in one appointment, it'll take maybe a couple hours. It could be several appointments. It really depends on the individual and their preferences. But if you're including like a healthcare surrogate or a power of attorney, that could take multiple appointments. But and then I email the documents out to you. You then sign and get them notarized, and then they're effective. We keep the case open. Generally, my my process is that I keep it open for a week, make sure everything's good, and then we close. Yeah, go ahead.
The form with the healthcare and the power of attorney, I can download and fill out myself. With the SDM, can I download the form and fill it out myself?
Okay, so no, not currently. You can't. We can send you a copy of one so that you can do it yourself, but I generally recommend that you come to someone like myself, not to toot my own horn, but just to kind of help you along in the process, because it is confusing. It's a 13-page document, so it is pretty long, and there is some legalese in there, so it's typically pretty hard to interpret for a layperson. So that's why I recommend coming to someone like myself. Yeah, go ahead.
I have one last question that's piggybacking off my first question.
Sure.
Was during that intake, when you go through the question and answer, I'm under the impression that if guardianship was the direction, that by the end of that little intake, you would say, I think your family should consider guardianship?
Yes. So our intake specialists, our intake specialists are completely separate from myself. They will not do the questionnaire. They will do their own set of questions. And if they believe that guardianship is the way to go, that's probably what they'll recommend. They'll send some information referral for guardianship. If they believe you're a candidate for SDM, they might come to me if they're on the fence and be like, hey, Morgan, what do you think? And I might look it over and be like, okay, yeah, sure, or no. I've had scenarios where I've jumped onto calls with intake specialists and, callers, and kind of assessed them for myself and gone through the questionnaire. If they're unable to my general rule of thumb is if they are unable to complete that questionnaire, even with a nod, yes or no, or they're unable to elicit a response in some way, then I say, I don't think SDM is for them. But if they're able to, I like to say that sometimes I can work some magic and get that SDM agreement crafted, despite what the parent or guardian believes their limitations may be. And I'm not trying to throw you under the bus. I'm just saying, like, that's typically what my process is. Any other questions?
Okay.
Yeah.
Yeah. Anyway, so when we call, can we say we were at a conference with you and we would like you to be our representative?
Yes, you can.
If we're approved.
You can.
Okay.
And most of the time, so I'm saying most of the time because now my supervising attorney is sending out some SDM cases to other advocates on the team just so that they can have some experience with this. But typically it does come to me. I am the person that does supported decision making for Disability Rights Florida right now.
Okay. What is the fee schedule for this?
We do not charge anything. We are completely free. So our services are completely free. Every time you get on a call with me, it's completely free. And we because we are the protection and advocacy system agency for the state of Florida, we do not charge anything. Go ahead.
And you were going to give us contact information.
Yes. So I believe my contact information.
It's in the book.
Oh, it is?
It's right here.
So this is the QR code for the survey. I have some general business cards that are back on I believe, the table back there that you can use to call our general intake line. If you need my direct line, please come up to me and I will provide it to you. And like I said, my name is Morgan Petipa. So if you, and the contact information evidently is in the book. And also, I have some business cards of my own that my dad is passing out. So, and that lists my direct line as well. Of course. Thank you all for coming.
Thank you.